Hello everyone, this is the analysis of the legal aptitude portion of the mock test 5. This particular mock test was based on the CLAT pattern and had 150 questions in the legal aptitude section, out of which the 40 questions, the question number 151 to 190 were your legal reasoning questions, and the rest 10 questions were your legal knowledge based questions. So let's start with the analysis of these questions. Coming down to question number 151, this was a question based on the topic of constitution. It has been marked correctly by most of the students, and the question dealt with the right to freely profess and practice and propagate any religion. The correct answer for this question was option C, that is, ban does not violate the freedom to practice religion, as bursting crackers is not an essential practice. What did the facts say? The facts said that in a recent study conducted by the Ministry of Health, it was found that air pollution level rises by 450% on the day immediately after Diwali, causing increased risk of lung cancer and respiratory disorders. So the government of Delhi, they decided to issue a ban on the use of crackers after 8 p.m. to cut down on the pollution level. Now, when this ban was applied, it did not curtail the freedom to practice or propagate any religion. It just curtailed the time period, it just regulated the mechanism of uh, enjoying the festival or celebrating the festival. So there was no ban on the freedom of practicing or propagation of religion. So therefore, and moreover, the explanation says that the activities that are not an essential part of religion can be reasonably restricted. So this particular ban was clearly under the purview of your reasonable restriction. Therefore, the answer would be C. Coming down to question 152. Now, this question has been a very doubtful question, because most of the students have marked B, maximum percentage of students have marked B as the correct answer. Then, other than B, students have marked C as the correct answer. So let's see this question. The principle says whoever voluntarily corrupts or fouls the water of any public spring, reservoir, so as to render it unfit for consumption commits an offense. Now, there was this guy Mr. A who belonged to a lower strata, and he drew water from a public reservoir. The people of upper caste objected to this, and because of their belief that the usage of water, the belief is that usage of water resources by such people pollutes the water, and the principle talks about voluntary corruption or fouling of the water. Then the fact says a fight ensued and A was forced to spit in the reservoir due to some religious beliefs, and A was sued for fouling a public reservoir. Now option B says that A is not guilty, as using water from public reservoir does not amount to fouling the water. Now principle is talking about voluntarily corruption or voluntarily making the water voluntarily polluting the water. But over here, option B is talking about usage of a public reservoir even by a person of a lower caste. So A is not guilty, but the reasoning given over here does not fit as per the situation, because the principle is talking about voluntary corruption or voluntary pollution of the water. But B option is saying that because he used the water, that is why he would be held guilty. So that is not drawing from the principle. So therefore option B cannot be the right answer. Option C says A is guilty as he spat in the reservoir, therefore polluting the water. Now he spat in the reservoir, that was also not done voluntarily. Okay, it is written over here that A was forced to spit in the reservoir. So therefore C cannot be the option. Option A says that A is guilty as being a low caste, he touched the water, thereby offending the sensibilities of other people. This definitely cannot be the answer. So the correct answer is D. That is none of the above. Now coming down to question 153. This was a question on contracts. It's a fairly easy question and most of the students have marked it correctly. The correct answer would be option B, that X is not liable to pay since the consideration is unlawful. Moving to question 154. Again, it's a slightly doubtful question. It also deals with the concept of inevitable accident under torts. The principle says that an inevitable accident is that which could not possibly be prevented by exercise of ordinary care, caution and skill. Now, the facts are talking about a courier company through which a guy named Uday, he received a wooden carton from an old trusted client. Uday was a employee at the courier company. So he received this carton which has to be shipped to Mumbai through their express same day delivery service. The carton was usual in appearance and it was sent immediately to shipment. So it was ordinary in appearance, so no suspicion was there, so they did not make any checks and it was sent to Mumbai. Now on arrival, the carton was taken to Uday's office according to the regular course of business. Now something was leaking, a greasy liquid substance was leaking from the carton. Now one of the employee proceeded to open the case, and because it was nitroglycerine, the carton exploded and all people were killed. Now the principal is talking about an inevitable accident. So this entire thing, was it an inevitable accident or not? The principal is saying that any accident which could not possibly have been prevented by exercise of ordinary care, caution and skill. So a courier company, it is essential for them to know what are the contents of the box or the carton or whatever package that they are transporting from one place to the other. That is under their ordinary course of business. But over here, just because it was a trusted client, they did not even ask anything, no details about the carton that was being supplied, which was a negligence on their part, which was not an exercise of ordinary care, caution and skill. So they did not exercise any care or caution, and therefore Uday would be held liable because he was the courier of the goods and he should have obtained the knowledge of the dangerous nature of the contents in the carton. Although maximum students have marked A as the right answer, but C was also marked as the next most ticked answer, and C says that Uday is not liable as he was not bound to know in the absence of reasonable ground of suspicion. So that is not the practice, the usual, because they are a courier company, so it's their responsibility to check each and every carton that is being shipped. So therefore C would not be the answer. The correct answer option is A. Now coming to question 155. Now this question is on the topic of mischief, and the fact says that Manisha and Ridhima are good friends but very envious of each other's material possessions. Now Manisha's husband gives her a diamond bracelet on their anniversary. Manisha shows the bracelet to Ridhima, who turns green with jealousy on seeing it. Finding a golden opportunity, when Manisha is not around, Ridhima takes the bracelet and throws it in the swimming pool. Now Avinash, the domestic help of Manisha, sees this and manages to safely retrieve it back. The house help, he safely retrieves the bracelet from the swimming pool. Manisha files a case of mischief against Ridhima. The principal says that mischief is an act of causing injury to property. It's essential to see that there should be some injury to property. But in the facts, it's clearly mentioned that the domestic help Avinash, he had safely retrieved the bracelet. So there had been no injury to property. Although the intention of causing wrongful loss was there, but the first important thing, that mischief is an act of causing injury to property. So because there had been no injury to property, therefore Ridhma cannot be held guilty. Okay, the correct option therefore would be C, that Ridhma is not guilty because the bracelet has been safely retrieved and there is no wrongful loss. Most of the students have marked A as the answer. A says that Ridhma is guilty of mischief because she had intentionally thrown away the bracelet to cause wrongful loss to Manisha. So intention was there, that is correct, but the main essential is causing injury to property, but because there was no injury, therefore she would not be held liable for mischief. So answer C is the right answer. Moving on to question 156. Now this dealt with the topic of torts, which says that whoever carries on a dangerous activity for profit, so it has to be a dangerous activity for profit, shall be responsible for any harm that may flow from the activity. The fact says that the municipal corporation, it was carrying out some repair work of traffic light at night time. So at night time the traffic is very slow, so they are carrying on the entire repair work at night. A notification for this had already been provided in the newspaper the previous day, and for installing the new lights, heavy soldering and metal work was going on. Now while the workers were doing this, one of the street lights fell on the head of a passerby who was seriously injured. He files a case for compensation. Now the principal is saying that whoever carries on a dangerous activity for profit, so the entire work that is happening over here, this is not a dangerous activity because it's just what? Installing of new traffic light, which is not a dangerous activity. Neither is it for profit because it's for the usual usage of the citizens. It's not carried on for profit. So therefore the municipal corporation will not be liable for the injury that is incurred to the pedestrian. So the correct answer would be A. Now next, question number 157. It says, it's a question of contract. It's talking about consideration. So over here a father has promised his son that if you score good marks in your exams, he would give him his favorite bike. The principal says that when at the desire of the promisor, the promisee does something, it is said to form consideration for the agreement. So over here the desire of the promisor was the father. Okay, so father promised, so he is the promisor. And what was the promise? What was the desire? That he get his name in the top 5 meritorious students. Okay, so at the desire of his father, that is the promisor, Ravi worked very hard and secured first rank in class. So he did as per the desire of the promisor, the promisee, that is Ravi, he has done something. So consideration has formed, and principle 2 says that an agreement without consideration is void. So over here the agreement was that the father would give a bike to the student if he scores good marks. So his son has scored good marks, so he has whatever the consideration was required, he has fulfilled the consideration. So therefore the agreement could not be void. So now option A says the agreement is valid agreement and Ravi will be given a bike if he keeps up with his studies. So it's a very general statement, if he keeps up with the studies, whereas in this case he has already secured the first rank. So therefore A would not be the answer. Option D says getting good marks in an exam would not amount to a valid consideration. So this is wrong because as per the principle, Ravi, who is the promisee, has done something at the desire of his father, who is the promiser. So the consideration is there and it is a valid consideration. So the correct answer should be B, that Ravi should be given a bike whether he can drive it or not, because his father said that because he is too young to drive, therefore he cannot get the bike. So that is not the reason. There was an agreement, there was a consideration which was fulfilled, so therefore the promiser, that is his father, should keep his promise and give the bike to Ravi. Now moving on to question 158. Now again, this is a very simple question. Most of the students have marked correctly. The correct answer for this particular question was C, because the judge, who was a district court, was a renowned advocate in the district court, he was appointed as the acting judge of the high court. So because there was no, he was not appointed as a permanent judge, and the principle says that no person after the commencement of this constitution who has held the office as a permanent judge. So over here he was not a permanent judge, he was just an acting judge. So therefore he has not committed any wrong, and he is allowed to practice in the district court. Now moving on to question 159. 159, the question was a little lengthy, it took a lot of time in reading. It's a question based on the concept of cyber defamation and how publishing of material online would amount to cyber defamation. Again, this question was, although it was a lengthy question, but it was an easy question because most of the students have marked the answer correct, which is option D, that Anish is liable for cyber defamation because he sent derogatory information about the MD in order to tarnish his reputation. So, simple question. The correct answer would be D. Coming down to question 160. Now, question 160 again is a question on torts, wherein a master servant liability has been carried out. It has been mentioned in principle 2, and in principle 1 it states that in order to establish a tort of negligence, so question is that of negligence, it must be proved that the defendant owed a duty of care to the plaintiff, there was a breach of the duty because of which the plaintiff has suffered a damage. So the fact says that Mr. Mathur, he had a huge dog, and he has kept a new house help in his house who was asked to take the dog out for a walk, and Mr. Mathur did not tell him that the dog is dangerous and panics in crowded areas. So it was Mr. Mathur's fault. He did not tell Birju about the nature of the dog. Now Birju took the dog to a nearby park, and over there the dog bit one of the kids. So there was negligence on the part of Mr. Mathur itself because he did not make Birju aware of the nature of the dog. So the correct answer would be option D, that Mr. Mathur will be liable because he, being the master, asked Birju to take the dog and did not tell him about the nature of the dog. Now question 161. This is a question on the topic of constitution. And the two principle is talking about the principle against self-incrimination, that is, that no person accused of any offense shall be forced to be a witness against himself, and a witness against himself means that no person can be forced or compelled to confess a crime. So these are the principles given in the question. Now over here the fact says that there was this guy Wajahat who was arrested for a conspiracy which was made to attack Red Fort during the Independence Day. Now while in police custody, this guy, he was subjected to a lie detector test. Now this guy Wajahat, he confirmed his involvement and he gave up the leads of the people who were involved in the conspiracy. He just agreed to the names. He just confirmed his own involvement and he gave the names of other people. Now the police further investigated and found certain evidence, and whatever charges were framed, they were framed on the basis of the evidence that were obtained as an outcome of the lie detector test, and then the trial commenced. So this person was not forced to be a witness against himself, or he was not his statement was not taken after making him to forcefully agree to something. He was just subjected to a test because of which he took names of certain people. The entire investigation and the evidence that was found by the police was the basis on which the charges were framed. So therefore there was no violation of his legal rights, and then therefore the answer would be D, that Wajahat cannot claim violation of his right as he was never compelled to be a witness against himself. C cannot be the answer because it says that he was indirectly compelled, but over here he was not compelled at all, so therefore C would also not be the answer. Now coming to 162. Now in this case, most of the students have marked the wrong answer, so therefore we'll go through the entire question. The principle says an agreement without consideration is void unless it is a promise to compensate wholly or in part a person who has already voluntarily done something for the promiser. This is the most important line, and I think the reason for the incorrect answer option also. Now in the facts, the promiser is A, because A's son was reported missing. He issued pamphlets notifying the public about the missing son. Now B, he also saw the notice. He found A's son near the railway station and notified A. Now C, who was A's friend, promised to pay 5,000 to B as a reward for giving information about the boy. So now in this case, B becomes the promiser because he is promising to pay 5,000 for finding out A's son. Now B claimed the amount but C refused to honor. Now in the principle it says that if a person has voluntarily done something for the promiser, whereas in the facts, the person B, he has voluntarily done something for A, and A is not the promiser. Therefore he cannot claim the amount from C because he has not done anything for C. Whatever voluntarily he has found the boy, that has been done for A. That is why the correct option for this question would be option C, that B cannot recover the amount as the promise was made by C. Most of the students have marked A, that is B can recover the amount as he gave information about the boy, but the last line of the principle clearly changes the answer. Now moving on to question 163 is a question of family law. Now again, the principle has to be read very carefully. The principle says that the Hindu marriage may be solemnized in accordance to the customary rites and ceremonies of either parties thereto, and if such rites and ceremonies include saptapadi, the marriage will become complete and binding when the seventh step is taken. So the principle says that the marriage may be solemnized as per the rites and ceremonies of either parties, and if whoever like either side of the parties, whoever side of the parties rites and ceremonies are decided, and if that ceremony includes saptapadi, then only after the seventh step is taken the marriage will become complete. So over here, the marriage of A and B was solemnized as per rites and ceremonies followed in A's family. Now in A family, saptapadi was not required, though the family customs of B required a saptapadi, and yet it was not performed since it was not required to the family customs of A. So because they followed the customs of A's family and it did not require a saptapadi, so therefore the marriage would be valid, because the marriage may be solemnized as per the rites and ceremonies of either of the parties. So therefore the answer would be A. The marriage is valid because it may be performed as per the rites of either of the parties. Now coming on to 164. This is also a very easy question. The principle is saying that no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. So if either of these things are there, then the person who is employing the children would be held liable. So he was Although the boy was engaged as a doorkeeper, still he would be held liable for being made to work in a factory. So therefore the answer would be A. 165, question 165 says that uh, there was a person, Mr. Jones, who had retired from his job, and he had a 6-month-old German Shepherd. It's a dog, a 6-month-old German Shepherd, Roger, gifted to him by his son. So one day his wife and kids were not at work, so he was relaxing. A salesman had come who has kept ringing the bell. Mr. Jones was too sleepy. He did not open the door. The salesman came again and again started ringing the bell. Then Mr. Jones let Roger loose. He let the dog loose at the salesman, and the dog bit the leg. So the salesman sued Mr. Jones. Now, as per the principle, any person who intentionally uses force without the person's consent in order to committing an offense, intending by the use of such force, knowing it is likely that by the use of such force he will cause injury, fear, or annoyance to the person, then he would be said to use criminal force to the other. So clearly, Mr. Jones did not have any reason to let the dog loose. He had the intention to fear away or cause some annoyance to the salesman. So therefore, the correct option would be B, that Mr. Jones is liable as he injured the salesman by letting his dog loose on him. Mostly students have marked it correctly. So therefore, B is the right answer. Now moving on to question number 166. This is a question about abetment in criminal law. The fact says that A police inspector raids the house of B with a valid warrant. So A, who is the police inspector, he raids the house of B, who's the owner. Now B has a servant C and a driver D. So C is the servant and D is the driver. So when the policeman, he raids the house of B with a valid warrant, C, who is the servant of B, he willfully represents to A that the driver D is B. So he says that the driver is the owner. So therefore, in the mind of A, D, who is the driver, is considered to be B, which is the owner. So C has, because he willfully represented, so therefore A because would be the option, because it says that C willfully caused the abetment. So the answer option would be A. Now question number 167. It states that all parties entering into a contract must be competent at the time of making the contract. A minor is not liable for necessaries supplied to him. And a minor is not competent to contract, and a person below 18 years of age is considered to be minor. Now over here, there was a guy who was 16 years old and he was regularly buying cigarettes from a shopkeeper on he did not pay any amount. He was used to pay the shopkeeper on monthly basis. So he kept buying the cigarettes and at the end of 2 months refused to pay. So because he was 16 years old, he did not have the capacity to enter into a contract, and the contract was not that of the necessaries. So therefore, Ishan would not be liable to pay because he is a minor. So the correct answer option is B, that Ishan is not liable to pay since he is a minor. Coming to question 168. Now this question is based on the concept of contract and the topic of wager, that wagering contract is void in the eyes of law. And the explanation also tells what is a wager. So wager is a promise to give money or money's worth upon the determination or ascertainment of an uncertain event. Then it also says that outcome of a game where the result is based on skill more than chance shall not be considered an uncertain event. And the facts: two students of the same school, while returning from school, they decided to play a game of billiards. Now, billiards is a game which has some involvement of skill. The game does not depend on chances, it's based on skill set of a person. So because it depended on the skill set, therefore the outcome, as per the explanation, the outcome shall not be considered as an uncertain event, because as per your skill you can change the outcome. So therefore this act would not be considered as a wager. The correct option would be C, because a skill is involved in the game, it's not a wager. Moving on to question 169. Now in this question, it dealt with the discrimination of people on the basis of religion, race, caste, sex, place of birth, or any of them. And explanation says that any educational institution may include special clauses that support the admission of students from minority groups. Over here, the institute is a minority institute and it has 80% seats reserved for Muslims. It does not take any grant from the government, although the government has offered the grant. So it's a privately managed institution, it's a minority institution, and it's not taking any grant from the government. So it can take decisions on its own, it's not bound by the guidelines of the government. So therefore A is the answer in this case, because the court will not decide, because it's a private body, it's not taking grants from the state, so therefore the court will not decide in his favor. Now moving on to question 170. This question is a question of criminal breach of trust. Over here, if any person in any manner, if he has some property and dishonestly misappropriates the property or converts to his own use, then he commits the criminal breach of trust. Now in the facts, a resident of Mumbai who is an agent, he got some amount from one person to be invested in a particular venture, but as the person, that is Devansh, he took the money as he was in need. So he took the money for himself and decided that he will pay back the amount whenever it's possible for him. So as per the principle, he has clearly violated the trust, and he was entrusted with some amount, he was entrusted with some property, and he dishonestly misappropriated the property to his own use. Although he decided that whenever he has money, he will invest in the company's paper and earn some profit in his own transaction. So he took the money from Dharamveer, invested for his own self, and decided that later if he makes money, he will invest in the company's paper and earn some profit. So clearly it's a case of criminal breach of trust, because he used his client's money for his own purpose without his approval. Now moving on to question 171. It is a question about fundamental rights. Principle 2 says fundamental rights cannot be waived. That means you cannot give up your own rights. You cannot say that I'm giving up my right, now would not be any longer subjected to any fundamental right. No, you cannot waive off your right. Principle 1 says right to life does not include right to die. Now, as per the facts, there's a person who was a criminal, and he was undergoing imprisonment, and he was diagnosed with pancreatic cancer and in his last stage. So, because there was no cure for it and there was hardly any scope for his cure, he filed a case of euthanasia, that is mercy killing, on the ground that he is suffering an unbearable pain. So therefore, because right to life is not included under right to die is not included under right to life, therefore B would be the answer, because no person can waive his right to life. This is as per principle 2. Next question, 172. In this question, the principle is regarding the performance of the promise from a third person. Most of the students have marked this question correctly. It's a simple question, and the answer would be option B. Only a part payment was made by Y, therefore Z can sue X to recover the balance amount. Coming to question 173. This was also a pretty simple question, and most of the students have marked the answer correctly. The correct answer is A, that no marriage exists between A and B, as they were in degrees of prohibited relationship, and it does not matter whether they live together for 10 years, because they were under prohibited degree, so it would not be considered as a valid marriage. Now question number 174. It's a question on the topic of torts, the subject of torts, on the topic of negligence. Now in this entire case, the doctor, he was negligent in the operation, and he had he had intertwined the two veins, and he had intertwined the two nerves and stitched them interchangeably, because of which there was infection. So therefore there is a clear negligence on the part of the doctor, and therefore Vijay can succeed because he agreed for the surgery but not for the negligence by the doctor. Next question, 175. This is a question on the concept of dowry death. Over here, Madhu was 8 months pregnant, okay, and she was asked by her in-laws to get the sex determination done of the child. So they wanted an abortion if it's a female. Madhu refused to get the ultrasound, and as a punishment she was locked in an isolated room. Next day she was found dead, hanging from the fan. So her parents filed a complaint for dowry death. So the correct option is A, that Madhu's in-laws are reliable, because keeping a female in an isolated room as a punishment, locking herself, is definitely cruelty. And secondly, she had been married only for 10 months, which clearly says that it amounts to cruelty. So therefore the answer is A. Now moving on to question 176. It's a question on the topic of constitution, and it says that the state is considered as a sovereign entity, and no employee of the state shall be held liable for the acts committed by the course of performing the sovereign duty of the state. And then sovereign duty includes all the acts done by a servant of the state while on duty. So although in this case the driver was negligent and the injury that happened to the pedestrian was because of the negligent driving of the act, but because he was performing the sovereign duty, he was at that point of time driving the URD minister from one place from airport He was taking him to the airport. He was performing a sovereign duty, and the accident happened in the course of employment. Therefore, B will fail as the accident occurred in the course of discharge of sovereign function of the state. Moving on to question 177. Now, this question is about your culpable homicide and murder. In the given facts, this guy Stephen, he was furious with Lela for not accepting the marriage proposal, so he burns her up in the hospital. He fires up the bungalow of the girl, due to which she sustains burn injuries. Now she is taken to the hospital, and over there, on account of maladministration of anesthesia during the time of operation, she died. So Stephen is definitely guilty of some offense, but because the reason behind the death of Lela is not the burn injuries, but it is the maladministration of the anesthesia. Therefore, Stephen would not be held liable of murder or culpable homicide, because his burning was not the leading point of the death of Lela. Therefore, the correct option is C, that he is neither guilty of murder nor guilty of culpable homicide. Most of the students have marked B as the correct answer, that is, he is guilty of culpable homicide. But over here, because the reason of the death was the maladministration of anesthesia and not the burn injuries, therefore Stephen would not be held liable for either of these offences. Now coming down to question 178. This question deals with the offense of culpable homicide. Now in this case, what happens is there is one guy who two people who were very good friends. They had shops next to each others, and while having lunch one day, one of the friends was making fun of the other's height. The other person got angry and started punching. The other person got irritated and slapped him tightly. Rahul got angry, and because Ankit was making fun, so he slapped him tightly. Now Ankit, in retaliation, started punching him repeatedly on his neck, which is a very delicate area. Now to his surprise, Rahul fell on the floor, and seeing this, he took him to the hospital, where he was declared to be brought dead. Now the reason behind the death was the collapse of carotid artery situated at the neck. Now Rahul's wife files an FIR against Ankit. Ankit is guilty of culpable homicide as he hit Rahul on the neck. The neck is a sensitive area. Any person would know that hitting on this area would cause certain injury. So he definitely had the knowledge. Now principle says that whoever causes death by the intention of causing death, or, because it's not and, it's or, either by the intention of causing death or intention of causing such bodily injury likely to cause death, or with the knowledge that is likely to by such act to cause death. So although he did not have the intention, but he definitely had the knowledge that if he repeatedly punches him at the back of his neck, which is a very sensitive area, then Rahul is bound to sustain some serious injuries. So this was definitely under his knowledge. Therefore he would be guilty of culpable homicide. The answer would be A. Now coming to question 179. uh, again in this question, it's a question of involuntary intoxication. The fact says that Arjun, who doesn't drink, he is given a drink by his friends with some alcohol, so he gets drunk. But when he and his friends decide to go for shooting, he is able to win the shooting contest and shoots 9 out of 10 in the entire contest. So now, when he is able to score a 9 on 10, even when he is drunk, that means he is not so intoxicated, he is in a position to understand what is happening to him. He is capable to know the nature of the act. He is capable of knowing the nature of the act. So later, when they were heading home, and he fights with a person and shoots him. So he cannot take the defense of intoxication because he knew what he was doing. Although he was involuntarily intoxicated, but he was in so much senses that he was able to understand the act that he was doing, the nature of act he was able to understand, because he could aim so properly, he could shoot at the birds so properly. So therefore he would be guilty, as he was capable of knowing the nature of his acts even though he was voluntarily intoxicated. Most of the students have marked B, that he was because he was intoxicated involuntarily, he would not be guilty. So B would not be the answer, although he was involuntarily intoxicated, but he knew what he was doing. So therefore the correct option would be C. Now moving on to next question, 180. In this question, the question was again the facts were a little lengthy. It is talking about that trespass to property in torts. So over here, a person has entered into another's factory to get a ladder in order to save his wife's life. So the principle says that if a wrong is committed in order to prevent a greater harm, he would not be liable. So Ranveer would not be liable because he wanted to save Deepika's life. So therefore the correct option would be C. Coming to question 181, it says that state shall not deny to any person equality before the law or equal protection of laws. And again in this case, the facts clearly says that a person was denied admission at St. Stephen's private Christian hostel. That means that this institution is not state, okay? Because it's not state, it can do whatever it wants as per its own wishes. Over here, the state, because it's not state, it's not bound to follow the rule or the law of equal protection of laws. So therefore there would be Arjun would not succeed in the case because there is no discrimination against Arjun by state. It's because it's done by a private body, so therefore Arjun cannot go ahead, would not succeed in the case. Coming to question 182. Now question 182 states that employers are vicariously liable for the negligent act of the employees within the course of employment, and principle 2 talks about the when a act would be considered within the course of employment. Now in the facts, Sanjay is a driver who works for a transport company. Now he was sleepy one day, so he asked the conductor to drive the bus. So he was doing an authorized act, that is he was in control of driving the bus, but he did it in an improper way. That means he asked this conductor to drive the bus because he was feeling sleepy. So because he carelessly authorized Sanjay, hence he would be held liable. And as per principle 1, the employers are vicariously liable, so therefore AB transporters would be liable for the careless authorization by Sanjay, who permitted the conductor to drive the bus. Moving on to question 183. Again, it was an easy question. Uh, the principal said that the two Hindus can get married under Hindu Marriage Act as per Hindu rights and customs, and any marriage in contravention to the above principle is considered void. So, as per the facts, the girl, she converted to Hinduism. So, as the principle says, two Hindus can get married, so she converted to Hinduism. That means she fulfilled the eligibility criteria, right? The correct answer option is C. Most of the students have marked C as the right answer, so this is a pretty easy question. The correct option would be C. Coming down to question 184. Again, the question on torts on the topic of nuisance. It's again an easy question because the entire accident that happened, it was a mere accident. There was no intent. There was no Ramesh and Suresh, they were neighbors. Although they used to have frequent tests with each other, the next day when Ramesh was reversing his car, he bumped into Suresh and broke his headlamp and bumper. Now the entire facts, they revolve around the question of intention. It is important to note that the principle is saying that whoever causes injury, harm, hurt, annoyance or anything obnoxious to the community or individual by offensiveness, spell or appearance by causing obstruction or damage is liable for nuisance. So intention does not play a role in cases of nuisance. So because Ramesh has caused the injury to Suresh, therefore he would be held liable. So therefore the correct option would be C, that he is liable for nuisance as he damaged the car by breaking the headlamp and bumper. Coming to question 185. This was again a very easy question because there was an unlawful interference, so there would be trespass because the branches of the weed, it was coming onto Melanie's backyard. So therefore the correct answer option is D. Mostly the students have marked it correct. Next question, this question number 186, it's again a question on cyber stalking, and it's a little lengthy question. The facts are slightly lengthy, but it's easy. Most of the students have marked the options correctly, and the correct option is C. Now we move on to question number 187. This had been a slightly debatable question because it's a concept of bailment which comes under your special contracts. The facts are a little confusing because the fact says that in the entire agreement of night depository there was a clause which said that Mary shall use the night depository at her own risk. So when we look at the facts, it's clearly stated that after closing the shop, Mary had deposited whatever amount in the night depository. So till the time things were under her control, she had done her part correctly. She had safely come and put the bag in the night depository. So next morning, up till this point, there was no issue, no risk on her side. She had uh, collected the receipts and deposited it. The next morning, when the bank was open, the employee, he empties the account of the night depository on the counter outside the bank, which was his mistake. He's counting the contents of the depository on the counter just outside the bank, and at that moment a thief steals the bags. So when Mary was taking the amount to the bank at night, there was no risk, nothing happened in that point of time. So she had submitted the amount to the bank. Now bank becomes a bailee, and it is supposed to take as much care of the goods as a reasonable and prudent man would take of his own goods. Now, because the employee of the bank, he did not take reasonable and prudent care, he was counting the amount on the outside counter, which is not taking reasonable care. Therefore, the bank would be held liable. The correct option would be A. The bank becomes liable. There is bailment, since the exception clause does not exclude the liability of the bank as a bailee. So, because he is a bailee and he did not perform his part correct, therefore answer A is the correct answer. The students have marked C as the answer. Most of the students, majority, has marked C, but this is not the answer. The liability is excluded up to the point of submission in the bank, but once it is submitted, the clause does not say that bank does not have any responsibility. It does not exclude the bank of its liability of being a bailee. So therefore A is the correct answer. Now moving on to question number 188. Now this is a question of act of God. Over here, students have majorly marked A as the correct answer, that Anil would be liable because he persuaded Mukesh to check the antenna while it was drizzling. So see, when it is drizzling, it means that there might be, the rainfall might get heavy, okay, that from drizzle the degree of rain would increase. That is the general expected flow. But the reason for the death of the television mechanic, the repair mechanic, was he was struck by the lightning. When he was checking the antenna, the lightning struck. So the probability of striking of the lightning is very far-fetched. That could not have been foreseen. If it was drizzling, the foreseeable event was that fine, there might be a heavy rainfall. From drizzle, the degree would increase. It would start raining, but all of a sudden a lightning would struck. That was not expected. So that is not a foreseeable event, and it could not have been avoided. Therefore the reason is act of God, and that is why the correct answer option is C, that Anil would not be liable as it was an act of God. Coming now to the next question, that is question 189. Now this is a easy question. Students have mostly marked it correctly. It was a question on contracts. Over here, there was a contract entered into two parties, but because of some government law, the manufacture and supply becomes illegal. Therefore the contract becomes impossible to be performed. Therefore the correct answer option is A. Now moving on to question 190, that is the last question of the reasoning question. Now question 190 is the least attempted question by the students. This question was on the topic of arbitration, which is slightly a not much read topic, and the facts basically dealt with a part of a contract. The facts clearly stated the a clause from the contract, and students had to decide whether this amounts to a valid arbitration agreement or a clause. So the principle is talking about mutuality with regard to initiating of proceedings. This means that when there would be a dispute, the arbitration proceedings will initiate. That means an arbitration proceedings will begin. So there should be mutuality with respect to starting, that there should be a common acceptance, a common reason, you can say. Both the parties should equally agree for taking the proceedings to arbitration. But as per the clause that is given, if we read the clause, it says that in the event of any dispute or difference between the parties, the contractor, after 90 days of presenting the final claim on disputed matter, may demand in writing that the dispute be referred to arbitration. So it is a one-sided thing. Only the contractor has the right to refer the dispute to arbitration. So there is no mutuality. There should be mutual consent. It's not coming from both the parties. So therefore, this type of clause or contract would not be a valid arbitration clause. So that is why the correct option is option C, that is, the arbitration clause is not valid as it lacks mutuality as regards to initiation of arbitration proceedings. Students, this is the least attempted question. The students, those who have marked the question, have also marked A as the answer majorly. A would not be the answer because it's talking about the fact that both the parties have signed the documents mutually. So it should not matter. But the principle is talking about the validity of the clause. Even if the parties have signed the document, the clause is not a valid clause. It's not a correct clause. So because it's lacking mutuality, so it would not be a valid arbitration clause. Hence the correct option would be option C. Now let's quickly come down to the legal knowledge questions. These were majorly attempted correctly by the students. The answer to option question 191 is B, that is an act of God, because it's an earthquake. Question number 192, this was majorly marked wrong by the students, so you really need to look into the concepts. The correct answer option is B, that is battery. Battery means where physical force is exerted. Assault is creating merely an apprehension or fear in the mind of the person, but there is no physical force involved. The physical force is involved only in the thought of battery. So the correct answer option is B. For question 193, mens rea is absent in the case of public nuisance. Nuisance would comprise only of the damage caused by the party. Intention does not have a role to play. Coming on to question 194, the territorial waters of any country, they extend up to 12 nautical miles. Then question 195, there is no person who can take the plea of ignorance of law. So the answer would be D, that is none of the above. Coming down to question 196, the question is about theft. So the first essential ingredient of theft is whoever takes or moves a property, and the property is movable property. So in theft, a movable property is involved. Coming to question 197, the word Hindu used in Hindu Marriage Act includes all except Parsis. If you look up the definition of Hindu in the act, it is inclusive of Buddhists, Sikhs, Jains, but not Parsis. Question 198. The case which is famously known as the national anthem case, it is B. Bijoy Emmanuel versus State of Kerala. This is famous as the national anthem case. Question 199. Environmental Protection Act came into force in 1986. So it's a factual question. And last question, that is question 200. The right of private defense of property is available in cases of what sort of property? So the right to private defense is available to both your movable property as well as your immovable property. Okay, so the correct answer would be option C. So here's the entire detailed analysis of your LA portion of LST Mock 5. Hope it has clarified the errors that were there with the understanding. Thank you so much.